Oh, do it. I mean, it's not like it's 18,000 people gonna. We're using it heavily, and then we will edit it so we'll then start posting different pieces, and then you guys can all get a copy of the actual recording or get a link to the recording. So if you ever wanted to go back to it, you could. So, all right, we good? All righty, okay. Hey, you guys, this is Raquel Nicole, and I'm here with my lovely guest,
Dinesh Chawla,
with
Chawla Legal Group.
So we're here in Detroit, and thank you for those that did come. I just realized I have gum in my mouth, but okay. Hold on one second. I gotta cannot talk with gum in my mouth. So actually, okay. All right. So we're back. So this is a real conversation. So Dinesh and I, long story short, is we actually grew up pretty much together. Mm-hmm. So we've got a lot of different connections. But the other day, maybe about a month or two ago, he and I were talking. I was like, I want to trust. And he was like, well, what kind of trust? I'm like, I don't know, a trust, And so he's like, there's what? You said it was like, how many different trusts? He's like,
about 87 that I can rattle off.
I was like, what? So, and I initially tried to be Raquel and utilize chat and everything. And I'm like, this is too much, right? And it's an actual like legal document, Mm-hmm. So that's when it clicked. And I already had started thinking about doing this episode, which this is a little bit different than the normal 50 Shades of Life, which is the podcast that I host. We've been running now October 2023. So what, 2-3 years? However, this is like a segment because we were starting to do so many interviews to where we were like, we want to get back to our roots. Then I was like, but I love interviewing. That is my day job. And I also love connecting people and networking. And I've had other conversations with people about different things that they wanted. So when I thought about it, I was like, okay, so this is Legacy Talks, and this is the Trust Edition, which is specifically for today's talk, which is why Dinesh is here. In our first segmented episode, I guess you could say, about trust. So we're going to get real. We're going to have a few questions. We're going to have a whole conversation. And then at the end, we'll have like about 10 or 15 minutes of any Q&A that you guys may want to ask. So give us a little bit, though, about how did you even get into trust and where did that all come from?
I got into it because, long story short, I was doing my own consulting thing in healthcare. And my parents came to me and said, hey, we need our trust reviewed. And I said, okay, when was the last time your lawyer reviewed it? And this was around 2016, 17 timeframe. Mm-hmm. And my dad said in 2003 when the guy wrote it. And I said, well, a lot's changed. Like, why haven't you had it reviewed? And he said, look, you're the lawyer in the family. What can you do here? And I was like, I don't even do this right now. So I went shopping for my dad. And I talked to a ton of people. And at the time I was doing a consulting job in Harrisburg, Pennsylvania. And I was doing a search online. This was before ChatGPT. So it was a Google search. And I came across this group called Lawyers with Purpose. And it was like a sign from the universe because one of the first lawyers in that group that popped up as a testimonial was this guy named Jeff, and he was in York, Pennsylvania. So he wasn't that far away from where I was staying for the consulting job. So I called him up, talked to him for about an hour and a half.
Wow. For free?
For free. It was a lawyer-to-lawyer thing.
Oh, okay, okay.
Good professional courtesy. He said you have 15 minutes, and then it turned into an hour and a half.
Okay.
So he recommended that I go see another attorney whose name I'm not going to mention because he's in our area.
Okay.
But that guy, we talked. He wound up doing my dad's plan. And throughout the process, he let me sit through every step.
Oh.
So
it's like mentoring you almost.
Pretty much. Yeah. When I got through everything, and the whole way through, I did a couple of estates and trusts clinics when I was in law school. And that was one of the great things about University of Detroit Mercy. Their law school has little clinics and like law firm programs where you're treated as an actual lawyer and an actual partner from around the area is teaching the class.
Oh, that's good.
So I remember taking the estates and trust ones. It was one of my favorite ones. And so it all kind of came back. That was right around the time that the Affordable Care Act was being repealed and replaced.
Yeah.
So my consulting business was kind of spiraling because it was in healthcare. And I was like, all right, I need to fall back on something. And I had my law degree and I had a newfound love for estate planning. What I was doing in healthcare consulting was focused on Medicare and Medicaid.
Okay.
So working with the elderly is kind of a passion of mine. When I hooked up with Lawyers with Purpose, their whole mission is to only allow estate planning and elder law attorneys into their group. So, I mean, at the time, all attorneys can join, but they're focused on
is like literally got it.
Estate planning and elder law. So estate planning spans across a lot of different things. So instantly I was interested because it's very easy to get bored.
Right.
Like I'm easily bored. That's probably why I'm single. I'm so easily bored that I can't keep anyone around.
That's another podcast episode.
Right. That's a different episode altogether. But with estate planning, what I found is that one, everybody on earth needs it. Like I've got a presentation that I do on a monthly basis. And in that presentation, there's a picture of my entire family. And it was from years ago because I wanted to have my mom and my favorite aunt in the picture. And it's one of the last ones we have of them. But it spans from I think the youngest person in that picture was about 3 at the time, or maybe just born. And no, it was my son. He was 1.5 or 1. So it went from 1 all the way up to mid 70s. And the point of showing that picture is that what I do in estate planning is the one form of law that I can think of that everybody at some point is going to need.
Yeah.
Because everybody is at risk of becoming disabled at some point. Everybody is going to die. And if you die, you have things that happen afterwards.
Right.
If you don't have a specialized plan in place, the government has a plan for you. And that forces you to go through probate so they can figure everything out according to their rules. That's the plan. So my point is there's a lot of people in that picture that needed a divorce lawyer at some point, needed a contract lawyer, a business lawyer, but not everybody needed that. Luckily, nobody in that picture needed a criminal lawyer. But we're all going to need an estate plan done.
That's true.
One of the biggest misconceptions about estate planning, because like there are some wealthy people in our family, there are some not so wealthy people in the family. Everybody needs a plan.
Yeah. Yep.
The biggest misconception is that estate planning is about assets. That's one of the biggest objections I have to overcome every time I'm talking to a potential client.
Really?
I don't need to talk to you. I don't really have any assets. I don't care. The first thing that we do is put control measures in for people when they turn 18. Estate planning at its core is about control. Yes, we use assets, but we want to control those assets. And if we can keep control of those assets, that's when your plan's going to work.
So I want to break it down into like super layman's terms. Okay. So I know what assets mean. I understand the word trust. So I want to break it down into like microscopic levels so that our audience on our podcast is actually around 22 to like 60.
Okay.
So thinking about my own son who's 23, right? And I have a daughter who is about to be 6 months, 21. So my question to you is first, let's explain what assets mean. What does that mean?
Okay. Assets is anything that you own. Anything. I don't care if you have a bank account with $1 in it. That's an asset. It can be anything from your bank account, a retirement account like a 401k, IRA. It can be a brokerage account like a traditional investment account. It can be a business. It can be a home, a vacation home.
Maybe a car. Okay.
Cars. Your bed. your clothes.
Okay.
I can keep going.
Yeah,
But
purses.
It's
maybe?
pretty much
Purses.
purses,
Okay.
yes,
All right.
and
Watches?
in some
Watches.
cases, valuable assets. Because we ask about, do you have any crazy collections
Yeah.
that we should
Yeah.
know about? Because we have to get into the assets. I need to understand how they're structured.
Mhm.
But
So even if you're like a toy collector
even if
or
you're
a
toy
shoe
collector,
collector or
that
whatever.
counts.
So,
And
okay.
so what we need to understand about all of those things is, how are they structured legally? Now,
Yeah.
I don't really think about the legal structure of your shirt. I don't really care about that. What
Mhm.
I'm talking about is your bank account, your retirement accounts, life insurance, things like that.
Okay.
Because if I understand that, if I understand that your bank account is in your name, or maybe it's a joint bank account,
Mhm.
are there beneficiaries on that bank account? Are any of those beneficiaries minors? Do
Mhm.
any of those beneficiaries have special needs or disabilities?
That's a good one.
These are all things that we need to think of, because if I die and I have a beneficiary designation, that's a contract between me and the bank saying that when I die, when one of these people on this list here comes in and presents you with my death certificate, you're going to cut them a check for whatever amount we have listed in this contract.
Okay.
50%, 25%, 33%, whatever it is, you're going to cut that person a check.
Mhm.
If that person is a minor can't own property outright. So what I've just done is created a conservatorship situation,
Mhm.
which means the court's going to take control of that money, and we can't use that money unless the court okays it.
Wow.
So these are the things that a lot of people don't think of.
Mhm.
They think a trust is just a document. It's
Mhm.
actually a set of rules, and those rules are your rules.
Okay.
They're your intentions. How do you want things to happen or flow? If I classify life in phases.
Mhm.
So right now we're all sitting here, we're all nodding, smiling, talking, we're alive and well,
Mhm.
right? Then there's a little phase that some people go through, not everybody, but it's sick but not dead, right?
Mhm.
Like you can't really function on your own.
Yeah.
You're sick enough, but you're not dead.
Mhm.
In those situations, we want to understand, again, this is a control measure. We
Mhm.
want to understand who's looking out for you in those situations, who can speak for you legally and has authority to make your decisions for you when you can't speak for yourself and you're at your most vulnerable.
Mhm.
That's what we need to understand. And again, that's a control measure that has nothing to do with assets.
Okay.
That person, you're giving that person authority to like manage your assets or help you control your assets while you're in that incapacitated state.
Right.
But it's not for their benefit, it's for yours. They're a legal agent of yours now.
Mhm.
They're acting on your behalf. They have certain responsibilities that we refer to as fiduciary responsibilities.
Okay.
It's a very powerful thing, and the law takes it very seriously, because you're, as a fiduciary, the person you're taking care of this person. You have to put their best interest and their well-being above your own. So if you break that duty, the courts don't look fondly or happily upon that.
Okay.
So again, we can avoid those situations where we need to go to court for a conservatorship, or commonly people hear guardianship. So guardianship is over the body and medical decisions.
Yeah.
Conservatorship is a lot like a guardianship hearing, but it's over the finances and legal decisions.
Yeah.
We couple the two with each other because oftentimes if you can't make your medical decisions, probably shouldn't be making legal decisions either.
Right.
Or financial decisions.
And and he brings up a good point, because I literally just went through this February. I had to call him up because my grandmother, and we also have somebody else in the audience that was helping me as well. But she fell the day after Christmas, and my grandmother was 102 at the time. Yeah, but still was okay. But she, that 102 fall was critical, right? And I thought all these years, because there's multiple business owners in my family and everything, and she at the time was in Houston, Texas. So I was actually at a work trip in New Mexico, and immediately went over to Houston because my aunts and my mom are in their 70s, and I'm like, you can't take care of her. anymore because she also has dementia at this age. So, at that age, that's when they become irate and upset or whatever. And then I realized, and he educated me, which is another reason why I thought about this, was because he was like, Raquel, does she have this and this and this? And I pulled out a sheet of paper that my mom and them had created when I was like 10. Mm-hmm. And it said my grandmother didn't want to be cremated. And it was just very basic on like a sheet of paper. It was dated and no signatures. It just said who was present. It had nothing else in it. It didn't talk about anything else. And then we realized, oh my goodness, she is not in the state of Mississippi, which is where her Medicaid was. Therefore, it was like a whole bunch of other stuff because she was in Texas at the time. So then we had to go through, and he helped me with, I'm going to let you utilize the proper words. I don't want to say the wrong thing.
No, you're good. You're good so far.
So that's when we had to immediately, because she was coming out of like almost like a hospice type situation. And we had to get her into a senior living home. But we didn't care for ones that were by Medicaid and Medicare, which means privately owned, which is a bazillion dollars a month. But in order for us to even make that decision, we had to have multiple documents in place and signed by the notary and all this. They even had to prove that she was capable of saying, yes, this is Raquel, this is my aunt, this and all this stuff. So explain to us, I know we're kind of getting a little bit off because I want to talk, that's like a whole nother episode, but at minimum, you should have, and tell me the documents, or tell everybody the documents that you made sure that we had for the medical, the legal, the financial, because I thought it was just one. Yeah. And I was like, oh, and I was so educated, and I want to thank you for that, but please do educate everybody else as well.
All right. So we just talked about the guardianship and the conservatorship. The ways to avoid that is as soon as somebody turns 18, they're their own person within the eyes of the law. Mm-hmm. I don't care if you can be on your parents' insurance till 26 or whatever the age is. I think it's 26.
Yeah, it's 26.
I don't care if you're 35 living at home. Once you're 18, you're in the eyes of the law, you're your own person. You're a legally responsible human being. So as soon as that happens, if that 18-year-old gets injured, sick, can't take care of themselves for some other debilitating reason, who's there to look out for that person? There's no law that says the parents get to do anything, even though the kid's over the age of 18. So the parent, and we do this for the parent's peace of mind more so than the kid.
Right.
But on their 18th birthday, I'll come in with papers to sign. So I'm the best uncle at the birthday parties. It's so great. But the healthcare power of attorney, and there's multiple terms for it. You might hear patient advocate.
Yeah.
You might hear advanced directives.
Yeah.
With the healthcare power of attorney that I draft, it's got all of those things involved. Mm-hmm. So I just call it what it is, healthcare power of attorney. That prevents the need for a guardianship. Mm-hmm. Okay, because remember, guardianship is over the person, the body. A general power of attorney covers your legal and financial decisions. Most people care more about their financial decisions than their legal decisions. So you more often than not, you'll hear the words financial power of attorney.
Yes.
But they're referring to the general power of attorney. So the general and the healthcare powers of attorney, those are the two documents that are the base of any good estate plan.
Yeah.
Because again, that's transferring control over to somebody else when you don't have it, but it's your instructions.
Yeah.
So that way you don't have to worry about the court. And I'll give a quick example of how bad it is with minors. I have one conservator. I had a conservatorship. We closed it out. I'm sorry, not closed it out, but I'm off the case now. But the conservator, the way it worked out, it was an ex-husband passed away, left insurance money to his two kids. One of the kids just turned 18. One was still a minor, was about 14.
Okay.
So the mom, who's still living, deceased person's ex-spouse, got conservatorship over her son.
Okay.
She didn't lock up the bank accounts or restrict them according to court order right off the bat. And she used $5,000 of that money to get the kid braces. Got her kid braces. That's perfectly fine, right? In our minds, that's kid needs braces, you get braces and use dad's money for help. We went to court for the accounting because the judge has to review the annual accounting. And she said, what's this $5,000 for braces? And we said, well, she used $5,000 for braces. And the judge said, but that's against the order. And I said, I realized that, and it's supposed to be in a restricted account. I didn't realize that the account wasn't restricted until I saw the accounting. I said, but here's the documentation saying it's restricted now. All right. She's got to pay the court back $5,000.
Wow.
Pay it back to the account out of her personal account. Next time, get my permission. So it's not a fun process. That's my point. So we like to have those documents in place. We never know what can happen to our kid. Listen, I suggest getting life insurance on your kids as soon as they are born, especially as soon as they can drive. I'm a very protective person. So I want everybody who's 18 and over to be protected with at least those two documents.
That's right.
The very least, because that way, when you're dead, right? Other people are handling your affairs when you're dead,
right.
and we don't have to worry about you. And I know it sounds crass, but it's true.
Real.
Now, when you're alive, we still have you to worry about. So I don't care what anybody says when they say, oh, I don't want to burden any of my family. That's the whole point of doing my plan. If you're alive and sick, you're a burden on somebody. So why not make it easier on them and take the court out of it? Take the government out of it. So that's really why we put those documents in place for 18-year-olds. It's not really for them. They don't care. It's for their parents. It's for peace of mind.
So can an 18-year-old, going back to trust, so can an 18-year-old get a trust?
Yes, absolutely. Absolutely. And there are cases where they might need it. So you never know. Again, if I turn 18 and I come into a lot of money, then maybe I want a trust. Maybe I set up a trust so I can have somebody else manage it for me. But they can't touch it. It makes it a little bit harder. It's a little box around your money to keep people from embezzling.
So maybe if they become a YouTube influencer or something like that.
Potentially,
So let's go back into developing a trust. So we talked about assets. What else is it? What is like the next step?
All right. So,
and I don't know if this is a moment where we have visuals or
we can toss the visuals up there if you want.
Berto, the visuals.
So the slides.
The PowerPoint.
So first, I'm going to kind of talk to you about what a trust does. All right. A trust is an invisible kind of it's like a box. This is the visual that I usually use for people out there. I don't know if they can see it or not, but
can they see
people
right
just
here?
Listening?
Can they see this or no? Yeah.
But
can they see this? I don't know. We can share it.
Yeah, we can share it later.
Yeah.
But you can ignore all the words that are on the left of the screen. That's I know it's small print anyways. Those are just some technical things. The trust is essentially a box. And the way I can figure out if somebody actually needs a trust is just by listening to them. If they're speaking and answering my questions in a certain way, then it's likely that they need a trust. One rule of thumb is anybody with minor children, I recommend getting a trust just to avoid that conservatorship situation that I was just talking about.
Right.
So if an adult passes away and leaves all of that money to trust, well, now the trust owns it. It's for the benefit of the child, but the trust owns it. So that's the segue into how I'm going to explain this. All right.
You guys got that?
So the reason I draw it like this, it's a box and it's open. There's letters outside of the box. The G stands for grantor. That's the person who creates the trust. That would be my client. All right. And we'll talk about myself as I'm the client. All right. So when I came to myself and said, I need a trust, that made me the grantor. I'm the one who's designing the trust, making the rules for the trust, and putting things in the trust. I, as the grantor, designate somebody to manage everything in the trust. That's
Okay.
what we call the trustee, and that's
Mhm.
what that T on the side stands for,
Okay.
trustee. So the trustee is the person who manages everything. All
So
right?
let me make sure I understand. So I'm going to use myself as an example.
Sure.
Feel free to use me as well. So I, Raquel, I'm the G,
Mhm.
and
Sure are.
it's a hey no. So
Oh, gee.
so I want to put my house, I want to put my car, I want to put my stocks and
Mhm.
everything else, my bank accounts and all that into this trust. So do I bring like my checking account? Do I bring statements to you, or
Yeah.
my mortgage? What do I bring to you first to start the process?
Yes. First, to start the process,
Okay.
you don't need to bring anything.
Oh, okay.
We have a process when people come through and ask for a trust, and we're designing any plan that we're designing. There's a process to it,
Okay.
right? So we actually have a vision meeting where we're figuring out what's going on in your life.
Mm-hmm.
How can we listen here and diagnose what are the legal issues that I'm hearing here, and
Mm-hmm.
how do I fix that with these things,
Mm-hmm.
right? So that's our vision meeting, and it's an hour long, and we're feeling each other out. Am I going to be the right fit for you as an attorney? Are you going to be the right fit for me as a client?
Okay.
But we're getting the goals and everything.
Okay.
Then we have our design meeting.
Mm-hmm.
That's where we're getting the nitty gritty of everything. The next meeting we have is a review, just to make sure that all the design points are
Mm-hmm.
in the drafts, because
Mhm.
there's a 2-week gap there. I draft in between the two meetings. And the second half of that meeting is what I call an asset review or a funding review. That's where I'm going to look at all of your bank statements,
Mm-hmm.
just to make sure that we have the ownership information, where
Mhm.
the account's located, what kind of account is it, checking, savings,
Okay.
things like that, money market. Then we move into different categories. Let me see the deed to your house if you have it, or just a tax
Mhm.
bill. So I
Mhm.
can see, is this a joint property?
Mhm.
Where is it located? Things like that.
Mhm.
So I have a good understanding of everything by the time we get to the signing of
Okay.
your documents.
Okay.
And then after the signing, before we deliver the documents, we help you fund the trust. I'll get into that a little bit later, but just real quick, because I mentioned the term, funding just means putting stuff in the trust.
Okay.
You have to legally retitle everything. And like I said,
Okay.
I'll talk about that in a second. But I want to
Okay.
get through this first.
Right.
So
Okay.
the grantor, the client, is the one
Okay.
putting things in. They designate a trustee, and that
Mhm.
trustee, and the reason there's arrows down
Mhm.
is that the grantor designates a trustee. The trustee is managing everything in the trust for the benefit of the beneficiary. That's what that B stands for.
Okay.
All right. There's a C on the other side of it. That stands for creditors.
Mm.
Okay. Because creditors can be a party to a trust, this type of trust, unfortunately.
Mm.
And then inside, you're going to see P and I. All of the pieces of property inside that trust have a value when you first put it in the trust. That's
Okay.
called a principal value.
Okay.
Okay. That's what the P stands for, principal.
Mhm.
So that's your initial value when you put it in the trust. If I have a house in there, and when I put the house in the trust, it was $300,000, $400,000,
Mhm.
then the principal value of that trust property is $400,000.
Okay.
The I stands for interest or income.
Mhm.
All of those properties in the trust, some of them will have the ability to earn income,
Mhm.
like say that one of those
Like
houses is
stocks
a rental.
yeah.
We got the chart there, supposed to represent a stock.
Mhm.
Yeah, piggy banks, so
Mhm.
savings, money market, whatever it may be.
Mhm.
But they all have those particular items might have the ability to grow in terms
Mhm.
of interest or create cash flow for you, which would be your income.
Okay.
Right? So the C, like I said, is creditor, and they get to, if the grantor is getting sued, the creditor of this particular type of trust can
Mhm.
step into the grantor's shoes. And if the grantor can get something out of the trust, a
Mhm.
creditor can too.
Oh.
Here comes some creditor law. The major rule of asset protection and creditor protection is if I can get to it,
Mhm.
with what they say unfettered access, meaning if I can just directly go and change the trust, take things out of the trust. If I am the grantor, the trustee, and the beneficiary,
Mhm.
which is how this particular trust is designed,
Mhm.
if I'm the grantor and I can change the trust anytime I want, and I get to manage everything and benefit from everything in the trust,
Mhm.
then my creditor steps in my shoes, which means they can benefit from the trust too.
Oh, goodness.
So this type of trust
Yeah.
is what we call a revocable living trust.
Okay.
The key goal that this accomplishes is it prevents any asset that is inside of that trust from going through probate.
Okay.
When I pass away, anything that is owned in my name and my name alone that doesn't have beneficiary designations on it
Mhm.
is what we call a probate asset. It will have to
Okay.
pass through the courts. So in order to avoid that with an asset, it means when I die, the asset can't be in my name. So how do I die with the asset not in my name and it still goes along with all of my rules? I retitle it to this trust. But
Gotcha.
because I retain a lot of powers and abilities with the stuff in this trust,
Mhm.
like the ability to dissolve the trust as the
Mhm.
grantor, the ability to change who the trustee and beneficiaries are, those are all powers. If I retain all those powers, then my creditors can step in my shoes and get stuff. So why do we use this trust? Because when I die, there's going to be other beneficiaries, right? I'm the lifetime beneficiary because during my life, I get to use everything in that trust.
Okay.
The beneficiaries at death might be my kids, could be my sister, could be my dad, could be a lot of people, it could be anybody I want it to be. There's no rules on who you can make your beneficiary.
Okay.
I would say there's suggestions on why you shouldn't make some people your beneficiary, but there's no rules on to who you can make your beneficiary.
Mhm.
Okay.
Mhm.
So where was I going to go here?
But the beneficiaries, do they have to be of a certain age?
No.
Though? Okay.
No. You can have minor beneficiaries because here's the thing. What we do is, so remember, we're the grantors, we're the trustees, we're the lifetime beneficiaries.
Mhm.
When I die, if I have a proper plan, then
Mhm.
I've planned for my death,
Mhm.
which means if I'm planning for my death and I know I'm not going to be here anymore, that means I have to have a backup beneficiary because I'm no longer the beneficiary when I die.
Right.
I have to
Okay.
have a backup trustee because I'm no
Right.
longer the trustee when I die.
Okay.
So here's the beauty of it. I, as the grantor, get to pick who my backups are.
Mhm.
And the legal term you'll hear for backup is successor. So
Mhm. Mhm.
that's, I say backup. I'm
Mhm.
simple. But I have a backup trustee, I have backup beneficiaries. So if
Mhm.
anything happens to me, if I'm in that sick but not dead phase, then
Mhm.
my backup trustee can come in and say, hey, look, here's a certificate of trust.
Mhm.
And it names me as the backup trustee. And this guy's clearly out of his mind. So let me help out here.
Mhm.
And the banks will honor that.
Okay.
Okay. So, how do we get things into this trust?
Mhm.
We take care of that.
Mhm.
Some lawyers don't. Some lawyers will just do the drafting and hand it to you and say, now put stuff in your trust.
Mhm.
If you get a trust like that, find a lawyer who's going to help you with funding. Okay. Find somebody who has a funding service because here's a stat that you might not have looked up.
I forgot about my stats. I'll do that soon.
It's in the high 80%. I don't know where it
Mhm.
lies right now, but last time I checked, it was 87% of trusts don't work
Wow.
because people will get the trust. They'll have their house in the trust because usually a lawyer who does the trust will say, we did the deed for your house, retitling your house into the trust, and we've recorded that deed.
Mhm.
So now your house, which is usually the largest asset outside of a retirement plan, but it's the one we want to protect the most because it's your shelter.
Mhm.
So,
Mhm.
so money we can always find. Shelter is tough.
Right.
So a lot of lawyers will just do that bare minimum and then hand you your documents. And I call that a paperweight made out of paper because it's a really thick document.
Mhm.
It's not going to do what you intended it to do because there's a whole host of other assets or stuff that's in that trust, or that should be in that trust, that didn't get in there because a lawyer failed to do what I think is a complete job. So we offer that as a service, which is why our trust service does cost a little bit more, because it's a little bit extra of what
You're
we
more
do.
protected.
Exactly.
Yeah.
It's going to work. That's the thing. So the 13% of trusts that do work, based off that 87% figure of the trusts that don't work, the 13% that do work were usually either funded by an attorney with an attorney's assistance. The people were counseled by the attorney and just told, hey, do this and then check in with us with evidence, trust but verify. Or those clients were engineers, because engineers follow every single instruction that you give them.
Right.
So when you hand them that like 19 pages of funding instructions that the lawyers will give, the engineers will go through it and they'll make sure everything on it gets checked off.
Yeah.
So those were the people that their trusts actually were.
A successful trust. Okay.
So,
and then the stat that I did find, since he's, making fun of my little baby stats that I had. So let me pull up, make sure I'm not reading anything wrong. Cause I was like, can I say stats? He's like, if they're right.
Yeah.
So
we're not here for misinformation.
100%. I agree with that. So let me pull back up my little stat sheet. Because I was actually shocked by this. This is why I wrote down one of these stats, because, when I sent out the invite or whatever, the one thing that I did say was, we always, and you said it, well, we always correlate trust with rich, right? And we're like, the trust, you have to be rich because it's going to cost, you got to have like $1 million, for you to be able to get in there. And then even though there are a nice amount of rich people, right, the number was still significantly lower than what I thought. And then I was like, wow, but this is something that is almost critical, because then I'm like, that means that the court sees a lot of probates and, just like, wow. So the number is 11% of Americans have a trust in place. So then of that 11%, you're saying 80-some% didn't even work.
Right.
So now you're into single digits. And then unfortunately, that person is probably dead thinking, I don't know what they're thinking, but the assumption was kind of like how I ran into my situation. I thought more things were in order. And that would be, as a mother, right, that would kill me, knowing that my kids didn't get what they were supposed to get, how they were supposed to get it. God forbid it was a creditor that came after and wiped something out or something. I don't know, catastrophic or whatever. So, and then the other one is only 26% have any formal estate plan, which that to me was even lower. So, and then, I think just hearing that to me was just a validation. Hearing that to me was was just another validation of why we should be doing this. So now I do have a question. So say, for instance, values go up and down of the items that we have in here. Is that why you have to kind of revisit what you're doing? Or, because I know you mentioned that earlier.
Not really. So the reason we do annual reviews with people.
So annual, okay.
I do annual. The State Bar of Michigan and the ABA recommend every 4 to 6 years.
Okay.
What happens every 4 to 6 years? We get political administration changes, and people come in and they redraft laws or they tweak things, right? So
that's a good point.
They say every 4 to 6 years, just to make things, are things still in accordance with the law? That's what they care about. I care about my client. So I want to understand, like, one thing we learned between 2019 and 2021 is that things can change like that.
100%.
Right? And if things can change that much from 2019 to 2020, globally and in our individual lives, then I got to think that since these are supposed to mirror your intentions and your life, maybe your intentions change too. Maybe during that period of time, there's a political rift in your family, and now you don't want this person to be your trustee because your ideologies are not the same anymore. Maybe you can't stand this kid because you were cooped up in the house with them for too long during COVID, and now you want them out of the trust. So you redraft.
Mm-hmm.
These are all things that we can do. People change their mind all the time. I had one client before we even signed the documents, she changed her mind about 15 times. I didn't mind. It's her plan. We got to meet her goals, but
that's crazy.
Could have gone without the 14th and 15th change.
Yeah.
1 through 13 were all right.
Can you, but speaking of a house, so say for instance, like, my husband and I, our house is in both of our names. Can I put my house into my own trust, or like, how does that work?
So yes.
Okay.
You both have interest in the house.
Yeah.
Right. So you can't, so married, it's difficult because you have a certain type of deed.
Okay.
So now hear me out here. We've talked about the trust being a contract, or we've talked about contracts. We've talked about asset protection laws and creditor laws. Now we're talking about real estate law.
Okay.
Okay. And property law.
Okay.
So, and this is all just in estate planning. So many different types of law here, right? So now we're going to talk about property law. The way married couples have their joint property is different. There's nuances as to a standard joint property. So if we went in on a rental or like a flip, then how we hold joint property is going to be different than how you and Bartel hold joint property.
Gotcha. Okay.
It's there's a different standard on how you can separate.
Okay.
Correct. Split it up. So you have to jump through some hoops. But yeah, if we brought it, if we retitled everything into that lesser standard, then we can split the interest. So we can, if you have separate trusts, which some married couples do, it used to be for estate tax planning purposes. We don't necessarily need to do that unless it's absolutely necessary. And for us right now, it's just not. I'll explain that in a second too.
Okay.
So yes, short answer, yes. All we have to do is write a deed from you putting your interest in the house into your trust. Okay. So when you die, then Bartel's roommate now is your trust, and whoever is the trustee of the trust. Okay. So yeah, or if you did a true split, then it would be his share would go into his trust, your share would go into your trust.
Got it.
Right?
Okay.
We do that a lot with blended families, because now if one person dies, because again, these are what we call revocable living trusts. You can terminate the trust, you can change it at will, right? So if we have a blended family, we always have to take that into consideration. Now we can do a joint trust and say when spouse one passes away, then 50% of the assets in the trust get locked away. The surviving spouse, the living spouse, can collect income off of all of that property, but they can't touch, change, or alter anything about that sub-trust within the trust. It's locked away. So that way they can't change the beneficiaries there. And this 50% gets locked up asset-wise for your kids if you're if you're the deceased part of the blended family. So because we see that a lot where
so it still functions properly. It's just
spouse dies. Living spouse says, I'm going to change this joint trust.
That's what I was going to ask. I'm like,
and knock these kids out as beneficiaries, and now my kids are beneficiaries. And they get 100%. So the state of Michigan actually tries to prevent against that. They have a statute. They've got it written into the statute that if it's a blended family, then the surviving spouse gets like $150,000 or $200,000 in assets right off the top, and then it gets split between the surviving spouse at I think 50% and the remaining kids from the blended family at 50%.
Wow.
So, or the deceased person's kids. I'm not quoting this properly, so I can read it to you later. This is not meant for legal advice. This is just educational.
She could be like, you said, no.
Right. Purely educational purposes. Yeah, right. All right.
Right.
So going back to this picture really quick, there's some words down here that are important. These are the common goals of a client, that when I'm listening to people talk and they say, I want to avoid probate, I don't want to leave any burdens for my family.
Yeah.
I want to make sure things are simple because the people taking over aren't as smart as me. And I want to
That's
make
true.
sure I want to make sure that I get asset protection on everything I'm leaving behind.
Yeah.
So we already talked about the fact that this particular trust doesn't get asset protection. That's why down here, full asset protection is in red. That's the only one of those 4 client goals that I can't accomplish with this trust. Otherwise, if it's properly drafted, it's a simple thing to do. It's our trust, and most trusts I've reviewed from other attorneys, they're all formatted very similar, and they're all just simple instructions that if you seriously go section by section, it will walk you through how to administer that trust. But you know what everybody wants to do? They want to skip right to the back and say, how much do we get and how can we distribute this? They skip over, completely skip over the part where you're supposed to pay like your creditors before you distribute anything.
Yeah.
So now we've got issues with that too. So asset protection is the only thing that we can't do with this trust, but it does, it avoids probate if, I should have this caveat in there, if it's properly funded. Because again, if you don't put all your stuff in the trust, then the stuff that's not in the trust is going to have to go through probate. So if it's properly funded, if you have that service taken care of, then you're good. And just to get back to funding real quick, like the expectation is that your attorney's office is at the very least, like the guy who did my dad's stuff, he's got a lot more resources than I do. So he actually has a staff that does all the funding. And what they do, they just write letters to banks and 401k companies and things like that. They just write letters and fax them out and make sure that, like, hope that things get done and ask for evidence that it got done, right? And then they close it out. I actually make a point. My assistant, Debbie, will figure out what bank we need to go to. And with the exception of Chase, because the client has to call Chase and make their own appointment, every other bank around here will let Debbie make an appointment, and I will go to the bank with you, and I will make sure that the bankers are doing what we need them to do. Because when we say, hey, we want this account to be in the trust, a lot of bankers, because it's a little bit more paperwork to actually change title, a lot of bankers will say, well, why don't we just make the beneficiary the trust? That way we just have to do a new signature card. It's a very simple process. But that's great. But what if the person becomes incapacitated? Now the bank isn't owned by the trust and we can't just seamlessly take over. Now we have to deal with the power of attorney and bank policy, not the law, because according to the law, the bank should be accepting powers of attorney. But bank policy says that it's a legal document that needs to be reviewed. So they're going to review it for however many days before they get back with an opinion to say whether or not this is valid. Now, in that time, the person who's under power of attorney might be incredibly sick. The bank doesn't care. So trusts are a lot more efficient in terms of beating the bank policy, not just the law, but bank policy as well. So if it's doing the deed, we record, like I will take it to if it's in the tri or quad county area, because I include Washtenaw, maybe even 5 because St. Clair. But I will go to the Register of Deeds and record it and then scan it and then send it to you. So we make sure that everything gets done and we have the evidence that we can put into your folder. And a lot of other attorneys do that too. I don't want to like single myself out here. But when you're looking, make sure that if you hear, oh, I can get a trust for $2,500 versus a trust for $4,000, figure out what the apples to apples are instead of taking that for an apples to orange. It's more expensive for a reason. Is this person just better? Probably not. We're all competent. It's not hard. It's really not. It's just a matter of understanding things and being creative. So.
And helping us get to the finish line as well.
So that $4,000 could help you better get to the finish line. Then great. If the $4,000 isn't offering funding and the $2,500 isn't offering funding, they're both drafting attorneys. Go with the $2,500. All right, just make sure to double check it.
Gotcha.
So the $4,000 might be charging an extra $1,500 for thoroughness.
Now, is it that, because somebody asked me this a long time ago when I was telling them what I was hoping to eventually talk about, do the properties, do they have to be paid off, or could they still be a balance, or like a
So,
house,
yeah, we can put houses with mortgages
Yeah.
into a trust.
Okay.
Um, we can put cars. We usually don't put cars in trust. We can pass those outside of probate we just go to the Secretary of State,
Mm-hmm.
and there's a form you can fill out, and they'll
Mhm.
transfer title.
Yep.
So
Did that not too long ago.
right. So that's a fairly simple process. We don't
Yeah.
want to put the cars necessarily in trust, but you can, and those cars can have
If they're like with
payments
value,
due.
or
Yeah.
okay.
Because again,
Not somebody's
'cause
hoopty, unless
well,
that hoopty is nice. So that's what
again,
you're
it's not
suggesting.
going to prevent. It's not an asset protection measure with this
Yeah.
particular trust.
Yeah.
Now, segue. If we
Okay.
go to the next slide.
All right. Did you hear that? Okay. Well, does anybody have any questions about this type of trust or anything? Anybody? Let me know before we move.
All right.
Okay. You have one? Okay.
Question with the revocable trust, if the assets have a beneficiary designated, or take that back. If an asset has a beneficiary designated, does it really have to go into the trust? It will still just bypass probate.
Wait, so repeat the question.
So I got it. So the question was, if somebody has a trust, or if we're drafting a trust or doing a trust plan for somebody, and they already have, let's say, a bank account with a beneficiary designation on it, wouldn't that beneficiary designation render the trust kind of useless because it'll go directly to the person? Yes, in that situation. Here's my response to that. If my son has special needs and he's listed in the trust as everything for him going into a special needs trust so he can continue to collect benefits, but I forget to change one of my beneficiary designations and it goes to him, let's suppose he's 20 or over 18. If it goes to him and he has special needs, that asset going into his name raises his asset limit. Now, what do we know about government benefits and asset limits? So I've just knocked him off of his state aid potentially.
Oh, yeah.
Because I've raised his asset limits and he can't have that.
Yeah.
So, and even with like, I get these confused. I'm between SSDI and SSI. So that's a means-based program. So if you're on it and you have too many assets,
they're like, use your own money.
You have to basically spend it down until you're back on it.
Wow.
So whereas if it went to the trust and the trustee was doing their job and held that in trust properly for you and only distributed enough to keep you going, but not get off of the benefits, or those that's no longer in your name, so you can have that money as stipends or monthly living or something like that, then great. We're not knocking you off your benefits, and the trustee can make sure of that. So now we've kept control in our hands, right? So that's why, like, if you have a trust, it's highly recommended that, and we do that analysis. Oh, you have bank accounts already? When we're in that bank, like I said, if the account's sitting in the trust, if we retitle it into the trust, now we don't worry about the beneficiary designations because the account's owned by the trust. There are some banks that you can't have the account title in the trust. All right. In that case, then we would say, all right, we're going to make the beneficiary the trust. So that way everything flows according to our intentions.
Brain's got to operate. You have to say it one more time.
So if I go to the bank,
okay,
and I say I want to keep this account in my name,
okay,
but I want to make the beneficiary
the trust,
my trust.
Oh, okay.
So now when I die, So there's two ways to fund a trust.
Okay.
One is called inside funding. That's where we put everything in the trust. One is called outside funding. That means when we die, there's a trigger to push that property into the trust.
Mm.
With a bank account, we would use the beneficiary designations.
Okay.
With an insurance plan, we would
Mhm.
use the beneficiary designations. With an IRA, a 401k, we would use the beneficiary designations. You
Mhm.
can't put a beneficiary designation, or at least with most, well, no, maybe, no, you can. Never mind, I'm going to take that back. Not even going to let that out there.
Yeah.
So-
Okay.
So, but you see my point. We can make the trust the beneficiary because, again, it's its own entity. It's its own
Okay.
thing.
Is it a cleaner process? Is that what you would recommend? Is it's a little bit cleaner to put it into the trust versus just having all these individual beneficiaries?
It depends, because there's certain nuances that I don't know what's going on with this property. I don't know what the intentions are. I don't
Yeah.
know. It just depends. Like
Okay.
if somebody wants to keep a house in their name because they're going for a mortgage, if a house is in a trust,
Mhm.
it's hard to get a mortgage on a house that's in trust. So generally what we'll do is, if it's in the revocable trust,
Mhm.
we'll pull it out, we'll pull it back into the owner, the trust, or the grantor's name.
Mhm.
And then we'll do the mortgage, and then we'll put
And then put it back
in
in.
the trust. Yeah.
Okay.
It's
Okay.
it's a cleaner process that way for the
Okay.
mortgage company and the
Okay.
bank to do it that way.
Gotcha.
So I'm going to introduce this trust.
Uh-oh.
This is another type of trust. This is what we call an irrevocable trust, but it's a very special irrevocable trust.
Mhm.
I am not the person who came up with this. There are a lot smarter people than me out there. I just kind of learn from them and use the tools that they give me.
Mhm.
So the way this particular trust is different than the other trust is it takes away some of your control.
Mhm.
The word irrevocable is very scary, right? Like, what's the first thing that you think of when you hear irrevocable?
Cannot be changed.
Cannot be changed,
Mhm.
right? Like, I can't get rid of this thing.
Right.
Like, my kids are irrevocable. So,
well, no, I'm just like,
no, they won't change. I tried, they won't change. So most irrevocable trusts are for specialized reasons.
Mhm.
Okay. A special needs trust is irrevocable. Trusts that we use for tax planning for the high net worth individuals is irrevocable. And when I say tax planning, I'm not talking end of the year, 1040, I got to pay my income taxes, tax planning.
Mhm.
I'm talking about an estate tax.
Mm.
In Michigan, the state of Michigan does not have an estate tax.
Mm.
So with any of my clients, I'm not worried about a Michigan estate tax.
Mhm.
The federal government does have an estate tax.
Mhm.
For any single individual who has, when they die, $13.9 million or more, they have to go through an estate tax.
Okay.
Is anybody in here worth $13.9 million as married or potentially single people?
Well, is that monopoly money?
No.
Or no?
It's real US dollars. USD.
Maybe somebody listening,
Maybe
or if I
somebody
hit this
listening.
mega million,
Right.
that's
So
845.
and that's changing to
Yeah.
to $15 million.
Really?
Yeah, that's part of the big beautiful bill.
Oh, okay.
So it's now going to permanently be $15 million for a single person,
Mhm.
and a married couple will be double that. So as a married couple, if you're worth less than $30 million, you don't have to worry about an
Oh, it's
estate
30
tax.
million if you're okay.
Married,
So
yeah,
this
because
is
they
single
double it.
is 50. Okay.
Correct.
Okay.
So right now the number is 13.9 for single and double
Mhm.
that for married. So it's around 27 something. The estate tax, the reason the ultra high net worth people don't want to deal with it is because for every dollar over 13.9 million
Mhm.
that I have, so 13.9 million that $1 over, instead of getting taxed at 39%, gets taxed at like 48%. So if you're in the $15 million range, or call it, we'll round up. So $14 million is the exemption. If you're at 15 million, $1 million, 480,000 of that is going to the government.
Wow.
So for the ultra high net worth people, we have to figure out, how do we prevent that much money going to the government when you die? So that's really where irrevocable trust came from, because the IRS says, if you don't control it and you can't benefit from it, then we're not going to tax you on it. We're not going to put it in your estate when you die. So in a standard, and this is not standard, but in a standard irrevocable trust, you're going to have a grantor, you're going to have a completely separate and independent trustee, and you're going to have a completely separate and independent beneficiary. And in order to make any changes as the grantor, you have to get an agreement from your independent trustee and the beneficiary that the change or the dissolving of that trust is in the beneficiary's best interest. Everybody has to sign off on that. And you can revoke an irrevocable trust. That's option 1 on how to revoke an irrevocable trust. Option 2 is go to court. So those are the hoops that you have to jump through with your standard, and that would be a closed box completely. All right. I didn't use that here in my example. I do in my normal presentations. I didn't use that here in our example because the bulk of people in this country won't ever need that. We're talking the top 8% of asset holders in this country are worried about the estate tax.
Okay.
The other 92% of us don't have to worry about that. And that's my target audience. I have maybe 3 individuals that are close to the high net worth. So we did a tax plan just to keep them down. But the bulk of my clients have less than $5 million. The vast majority of my clients have less than $1 million in total assets.
Gotcha. Okay.
Okay. So this is the trust that we use to protect those assets. A lot of people in the middle class or the lower upper class don't think about asset protection. I don't have that many assets. Why do I need asset protection? Here's why. If I have $10 million and I get sued and I lose $100,000, I might be mad for a day. But if I'm a thousandaire and I get sued and I lose $100,000, it's catastrophic.
It's catastrophic.
So the less you have, the more you have to protect, right? Because a loss is going to hit you harder.
That's right.
It's a catch-22 because the complexity of these and the cost of these, the fees for these are not that cheap, right? Which is why we offer plans. But the value's there. Like and this isn't my cost, so please, again, just for educational purposes. But if I told you that this costs $20,000, but it's going to protect $400,000, is that worth it?
Yeah.
Maybe, maybe not. When this is what my dad's in, and when the lawyer quoted him, it was around $15,000. Not just for this trust; it was the whole plan, like the wills, the powers of attorney.
Okay.
When we say trust plan, you're not just getting one document; you're getting all the documents that make up a plan.
That was going to be my next question.
No. So I saw it in your face.
So in the trust would also have your will.
Everything.
Not in the trust itself.
I mean, like
in the binder.
Okay.
Yeah. While we're going through that design meeting that I talked about, we talk. Who do you want if you're unable to act for yourself? Who do you trust to act for you? You give me a name. Okay, I put it in my system. That's who your agent under power of attorney is going to be. That's what's going to show up in that document. If we're doing a trust, it's a simple question. We say, who do you want your trustees to be? You give me a list. We put that in your document.
Mhm.
So that's how when I say design meeting, we're literally, I'm asking you questions.
Mhm.
Your responses are what's designing this plan.
Gotcha.
So we hit every single necessary document to make your plan complete,
Mhm.
from healthy to not healthy to now dead.
To power of attorneys, everything.
all of it,
Okay. That's
all that.
good. That's
Yeah.
good. Well, let me ask you this. I have two questions. So even in this one, let's say my net worth drops, or, say COVID hit me hard, and I'm no longer at this 15, 20 million or whatever. Now I'm worth 3 million or something. We have to get out of this trust, or?
No, there's no dollar limits as to, like, you
Okay.
can have this asset protection trust with
Mhm.
$1.
Mhm.
It's going to cost you 7,000, but but
Yeah.
but to protect that $1,
Yeah.
because here's the thing: if somebody comes after that dollar,
Yeah.
then you're covered, right?
Okay.
And that's what I'm going to get into. So,
Mhm.
with this particular trust, I'm going to make myself the client. All right.
Mhm.
Actually, what I'm going to do is I'm going to make my dad the
Mhm.
client,
Mhm.
because I already told you my dad's in one of these trusts,
Mhm.
or has one of these trusts as part of his plan. So when I'm going to tell this story really quick.
Uh-oh.
When we were in his lawyer's office, the lawyer did this thing where he said, you guys need asset protection. All right.
Mhm.
And here's why. Like, my mom was declining in health. So
Mhm.
qualifying her for long-term care assistance with Medicaid was in the forefront of our minds. And so he's like, you guys should have some asset protection, because Medicaid, the government, can be a creditor. I have C&P here. I should remove the P, but P stands for predators. So creditors and predators to your estate plan. But so we're sitting there, and the lawyer says, all right, here's the engagement agreement. It's going to be $15,000. And I'm going to step outside so you guys can think about this, grab myself a cup of coffee, go to the bathroom, and I'll be back in.
Mhm.
So my dad looked at me and he's like, what do you think I should do? It's a lot of money. I said, it is a lot of money. I said, but what kind of car do you drive? He said, a Lincoln. I said, how long have you driven a Lincoln? He said, a good 10 years. And how much does it cost to insure that car every single year? At least $1,000. So for 10 years, you spent $10,000 insuring your Lincoln. How much does your Lincoln cost? He's like, well, this one's about $56,000. I was like, so a $56,000 piece of property,
Yeah.
you spent $10,000 insuring, and you're telling me $15,000 is too much to protect your house, your annuities, that is your pension, your brokerage account, everything you got working after you
Mhm.
retired,
Mhm.
because he consulted in the automotive world after he retired from Ford.
Okay.
So he was living off a Ford pension and collecting consulting dollars.
Mhm.
He had some stuff banked.
Mhm.
So we put it in one of these,
Mhm.
the bulk of it. So here's how this works.
Mhm.
With this, remember I told you, in a regular irrevocable trust, you have to have independent trustees. So, because to make something an irrevocable trust, all it means is that we're just taking powers away from the grantor. We're just taking a little bit of power away. Not necessarily control. There's a difference between control and power. All right. So we're taking some power away from the grantor. We're not saying that he or she cannot be the trustee. So in this case, the grantor is the same person as the trustee. So in my dad's trust, he's the grantor and he's the trustee. So he's managing everything inside of that trust.
Mhm.
He allows himself, he retained the power, he kept the ability to keep or collect the income that trust produces.
Mhm.
Remember, we talked about principal and income? The power that he gave up was to benefit during his lifetime
Mhm.
from the principal value
Okay.
of the so he can't use any of the things in there to satisfy his creditors, because he can't get
Gotcha.
to the principal. his beneficiary during his lifetime can get to the principal. That beneficiary, there's two of them. It's me and my sister.
Mm-hmm.
So here's how this works. And this is where I usually stand, but I'm not going to. So here's how this works. If I'm the grantor and I put stuff in there and I'm the trustee and I get to manage everything in there, if I'm the trustee and the grantor and I decide I want to downsize my house because it's a 4,000 square foot house in Troy and I'm living alone now and I don't need it, and I want to buy 2 condos for the price of that house, I can, as the trustee, sell the house out of the trust, collect the money back into the trust. Right?
Okay.
See where I'm going with this?
Yeah.
Now I can use that money as the trustee to buy 2 condos
Okay.
into the trust.
Gotcha.
I can rent one of the condos while living in another condo. That rent is income.
Right.
So I can collect the income. I just can't put the principal, that value. I can't take one of those condos out of that trust and put it back into my name unless I get the beneficiary's permission.
Okay.
Okay. Or I distribute it to the beneficiary and then they distribute it back to me as a gift.
Gotcha.
So
okay. It's always
all
a way
tax-free.
around stuff.
all tax free, by the way.
Oh.
Okay. So here's the great thing. So if my dad comes to me, let's say I'm the only beneficiary and my sister's just waiting in the wings, because remember, this is just during my dad's lifetime. There's a separate rule for when my dad dies that now both me and my sister are the beneficiaries.
Right.
But during his lifetime, I'm the beneficiary. If my dad says, hey, you see that brokerage account in there? Yeah. I'm going to distribute $50,000 out of that brokerage account, give it to you so I can go on a vacation. I now have a choice. I can say, okay, Dad, or I can say no. If I say no, my dad has a choice too. He can say 2 words to me. One starts with an F, one starts with a Y. You're fired. What did you guys think? I don't. This could be a family show.
No, it's 18 and up, actually.
So my dad can write me out of the trust. That's the point. He retained the power to amend and to restate. That's one of his retained powers. Really, the main power he didn't retain was over the principal of that money. So if he distributes the principal to me, and if I say yes, then sure, Dad, fine. Because I don't want to say no and have him write me out of the trust altogether. Because he can. If I say no to him, remember he wants 50,000. I say no, and I keep that 50 grand. He can write me out altogether, both living and dead. Put my sister in there, and she gets everything, right? And she's the decision maker.
And still
you
no
think
vacation.
She's ever going to say no to him after she saw what happened to me?
Right.
So my dad has leverage there, right? Because he's indirectly controlling he's directly controlling who's in that spot. So he's indirectly controlling all the assets.
Okay. But in the other trust, you cannot do that.
Correct.
Oh,
well, in the other trust, he can just take as he pleases.
Yeah, that's true. That's true.
So here's where the beauty lies. If my dad gets into a car accident, he's 79. We know how old people drive.
I know how young people drive too.
Yeah, right. God, I can't. I'm not looking forward to my kids turning 16. But my dad's 79. He's in great shape. Everything's good with him. He's a good driver. But let's suppose he's not. If he gets into a car accident and gets sued, right, and they win, let's say my dad's not properly insured, and there's $100,000 judgment on him. With the other trust, remember the creditor, which a judgment is a creditor. That creditor steps into my dad's shoes, says, oh, you've got a trust here? Gimme. 100,000 comes out of the trust, and we just lost $100,000. With this one, creditor says, oh, I see you've got a trust over here. Gimme. And my dad says, I'd love to. You won fair and square. I messed up. I'd love to give you that 100,000, but I can't even take out 100,000 unless my son okays it. So now the creditor is going to come to me and say, hey, can we get that 100,000? And I'm like, I say to the creditor 2 words. One starts with an F, one starts with a Y. And they're the words you were thinking of the first time around.
I was not.
Liars. So, but that's,
Yeah.
I have that right,
Yeah.
you know? So,
Mm.
so that's why if you look back down into this lower right-hand corner,
Mhm.
you're going to see those 4 goals again.
Mhm.
Full control. It's not red. Remember how
The other
full
one was
asset
red.
protection
Yeah.
was red? Full control is in yellow because my dad has given up some control, but indirectly, he still has control.
Okay.
Number 2,
Say yes.
just like the other trust, if
Yeah.
this is properly funded, everything that's in this trust will avoid probate. So we've covered 2 goals now. It's simple if it's clearly drafted. I mean, it's a complex concept, but administering it is simple if it's clearly drafted. And again, I told you, we order everything in the process you should follow.
Mm-hmm.
Not my fault if you can't listen. The last one is full asset protection. Full asset protection. Let me explain what full means. We talked about the lawsuit and the judgment, right?
Mm-hmm.
Now think about this. I talked about a lawsuit and a judgment because of a car accident.
Mm-hmm.
What if I had my LLC that's a business in that trust and I got sued on a contract?
Mm-hmm.
Because within LLC, we have a bubble, right?
Mm-hmm.
People can't get out of the bubble. Everything that is liable is within the bubble.
Mm-hmm.
But that bubble is my personal property as well. So if I get into a car accident on my own time, people can get into the bubble because it's a personal thing. If I put that bubble in that box, can't get in from the outside, can't get out from the inside.
Okay.
Okay. So we've bubble wrapped your stuff and boxed it up. So again, it protects business lawsuits, protects personal lawsuits.
Mm-hmm.
Here's the kicker. If I put something in there and it's in there for 6 years, it's been sitting in there for 6 years. If year 6, day 1, I file for bankruptcy, the bankruptcy court can't look at anything in that trust.
Really?
Past their 6-year deadline. If I file for Medicaid to pay for my long-term care, they can't look at anything in that trust.
Wow.
Because it's past 5 years. Now remember, I told you we did my dad's estate plan in 2018-19 timeframe. It's way past 5 years.
Mm-hmm.
There's some assets in that trust.
Mm-hmm.
If my dad hurts himself or dementia kicks in or Parkinson's or anything horrible like that, and he needs to go to a nursing home, he can pay for 1 month private, you're 15 grand a month. And here's the thing. Over 90% of skilled nursing facilities in Michigan accept Medicaid as a form of payment. Once you're in there and you've private paid, and then your assets have dwindled and you've put in a Medicaid application, they cannot kick you out unless you're a danger to people in the community. So during that application process, and once you've been accepted into Medicaid, you're protected. So everything that we put in there 5 years ago, because there's a 5-year look back period for Medicaid. So if we put it in 5 years in advance and then we apply for Medicaid, they can't look at anything.
That's good to know.
So
That's
from a
good
middle
one.
class asset protection, if you're not in Michigan, there's a number. It's called, every state has it. It's called a regional divisor. In Michigan, it is this year just under $12,000. What that really means in real people talk is that's the average cost from the UP all the way down to the border of Ohio. That's the average cost that the Michigan Department of Health and Human Services has put on your monthly fees at a nursing home in Michigan. Just under $12,000, $11,842 to be exact.
Yeah.
But that's what they're saying the average cost is. Okay. So 12,000 times 12 months in the year, that's $144,000 a year. So if we can protect 1 year of that, great. The average person in a nursing home is there for between 2.5 and 3 years. Let's call it 3.
Mhm.
144 times 3 is a lot of money. It's
Yeah.
close. I mean, it's close to somewhere around there. Yeah, close to half a million, right?
Rain Man.
144
just
times 3.
kidding.
Yeah, it's close to $500,000.
Yeah. Yeah.
So again, we just saved that person $500,000.
Mm-hmm.
That person's
That's
family,
right.
really.
Yeah.
Scale it back down. If I have a client who's elderly and needs, let's say they've been in a nursing home for a year already, they've spent that $144,000 and they only have $144,000 left.
Mm-hmm.
What are they going to do?
Mm-hmm.
We use these trusts to protect the rest of their assets. We can usually, for single people, we can protect about 50%.
Mm-hmm.
Married couples, there's so many exemptions, we can usually protect 100% of their assets and get the sick person on Medicaid. Why do we do that? Is it taking advantage of the system? No, it's written into the law. I show people what we do. I have to hand in a stack of papers this big to the Department of Health and Human Services along with the application to show 5 years worth of bank records.
Mm-hmm.
Here's what we've done over the last 5 years.
Mm-hmm.
We're handing it all to you, but we've done everything by the book.
Mm-hmm.
So we're all good there.
Mm-hmm.
Now, we use these for high net worth individuals too that aren't at the asset exemption level
Yeah.
yet.
Yeah.
So if you have between $5 and $10 million,
Mm-hmm.
you're not too far from that 13.9. So we make sure that we protect as much as we can before
Mhm.
you hit that.
Gotcha.
Right.
Okay.
So that's really, when you hear things like generational wealth,
Mm-hmm.
that's how we start it. One of the best things that we can do with any of these trusts, I don't care which trust it is, but the way people get generational wealth isn't necessarily from what, this is weird, it's not necessarily from what they've accumulated while they've worked and lived.
Mm-hmm.
A lot of people create generational wealth because they started life insurance when they were young.
Yeah.
So they were paying a dirt cheap premium for millions of dollars of life insurance,
Mm-hmm.
or they've
Mhm.
accumulated life insurance as they age and they make the beneficiary a trust.
Mm.
So then that gets passed and passed and passed.
Okay.
Because if we live off of our retirement or our savings, hopefully we've planned and we can live a good retirement and life. But even as an estate planning attorney, I do financial advice too, but even as an estate planning attorney, I've always told my clients, live off your retirement and leave life insurance. That's what it's meant for.
That's right.
It's meant
Yeah.
for you.
Now, any questions about this one? Because I know we're getting close to wrapping up or
Yeah.
whatever. Any questions about this current one, the irrevocable one? No. Okay. All right. I did have one question about either one. Is it a hard process? Like, God forbid, I do have my kids as my beneficiary, and God forbid one of them pass. Is it I have to go back in and I have to go through the whole process all over again, or is it a simple? Okay.
No.
Okay.
The only time we'd have to go through a part of the process is if while you're living, you take one of the kids out,
Mm.
or you want to make a drafting change. Then
Mhm.
yeah, we have to go in, we've got to
Mhm.
change things. And when somebody says, yeah, it's going to be a simple change, that no, it's
Mhm.
not.
Mhm.
Because if we change things in this paragraph, I have to know how that change is going to impact every single paragraph afterwards.
Yeah. Or what if, I did have, say, my brother or
Yeah.
something, and something happened to
He
him,
dies for,
or he didn't die. Maybe
Or
he's just not,
with it. Right.
yeah,
He's
he's at,
incapacitated.
yeah.
So if they're incapacitated, we don't worry about that because our trusts always have clauses for people,
Okay.
for beneficiaries who are deemed at your death, if they're deemed to be incapacitated. Because
Mhm.
like we could be in a car with each other.
Yeah.
If I'm one of your beneficiaries and we're in a car with each other and we get into a car accident, one person passes, but one person's now incapacitated.
Yeah.
We have sub trusts that kick in that
Okay.
situation to make it a special needs trust for that person.
Oh, okay.
So that's taken care of. If the person
Mhm.
dies before you,
Mhm.
then there's clauses in there. And these are all client choices that we talk about during the design meeting.
Okay.
You can say, if this person dies before me, I want everything redistributed among all of my other named
Yeah.
beneficiaries. Or
Mhm.
you could say, I want that person's kids to get their share.
Okay.
So if that person was at a 25% share
Mhm.
and they have 2 kids, each of
Mhm.
those kids would get 12.5% of your estate.
Okay. Because that's why I was like, man, that would just be, God forbid, like my grandmother's now 103. And we're like, maybe she'll outlive everybody, and
And-
she's doing okay. She's in there, raising a little bit of hell. But, at the end of the day, but she actually is getting better being in the nursing home. But we're like, man, but you're right. I mean, you hit it dead on when you're like, you spend X amount of money and then what? Right. And I don't want my children to be in that situation because death has no age, right?
Yep.
So that's why I'm like, okay, let me think about this right now. But I guess if I had a trust and say I just at the time only have say 2 life insurances or something, but maybe I add more on this kid or me or whatever, can I put insurance inside of the trust at any time, or is it locked down? I guess I'm
So
Mhm.
yes, and yes.
Okay.
So, and this is what I love about estate planning.
Mm-hmm.
There's only a few situations I'll say no to one of my clients. The first situation is if they say, hey, can we do this with the trust? And that thing happens to be illegal. No, obviously we can't do that.
Yeah.
Second situation is if it's against public policy, like if we try to prevent somebody from, what do they teach us in law school? Like the common example in law school is if you had a gay kid and you said, no, you have to marry somebody of the opposite sex. That's against public policy, right?
Yeah.
So
Yeah.
So you can void out just that piece of the trust. It doesn't destroy the entire thing.
Yeah.
Okay. So, but it's stupid to void that out. So that's my second no.
Mm-hmm. Mm-hmm.
Then if a client comes to me and says, hey, I want to do this with my trust, and I immediately rattle off 15 cons and 1 pro, and I'm like, so you still want to do this? And they're like, I'm going to say no. I have a fiduciary duty. I have a duty as an attorney to not allow them to make a really bad decision. And if it's a really, really, really bad decision, I'm going to say no. Okay. Other than that, I say yes to pretty much everything. There's a solution within these documents that we can figure it out. There's a lot, and I'm not even going to say loopholes in the law. There's just a lot of things you can do. They want you to be, the government wants you to be able, at least the state of Michigan, because this is all Michigan law, trust law. They want you to be able to do as much as you can, but there are limits, right?
What's the time frame to get a trust? Like, is that a year, 6 months, about like a normal average person?
I've done one with very simple funding. I'm talking like bank accounts, a beneficiary change on life insurance, and the deed for the house to go into the trust. We got that done in 2 weeks.
Wow.
Could have been done a lot faster, but we couldn't get an appointment with the bank for 2 weeks out. So now we have one trust that's not completely funded, and it's been going on 2.5 years. And that's because there is sometimes, not all the time, sometimes there's this thing called the client's fault. And in this particular case, we've done our fair share of reaching out. We have gone through our fair share of canceled meetings. So in that rare case, it's taken quite a while.
Yeah.
Sometimes we're dealing with third parties. Like I said, with the bank, it took us 2 weeks. If we have to do something with a 401k or an annuity, some annuities, those companies want to hold your money for as long as they can, right? So when we're trying to move it around, restructure it, reallocate it, it can take them some time sometimes. Sometimes we send the information to a financial advisor or an insurance broker or whoever it may be, and they don't get back to us. They don't do their part for a while. And it's a lot of back and forth. So that can extend things. We like to get everything done within between 6 and 10 weeks.
So if I have property in other locations, other states, do I have to have a trust? Can I put it all still into this? Any other questions? Is there any other? I know you had another slide. Is there one more slide?
I did have another slide. It was just essentially, it's just showing the importance of funding the trust.
And that was
Because-
actually going to be, that was my other question.
Because
Funny.
again,
That was like my final one.
this is where I'll actually, if you have a trust, put stuff in it.
Mhm.
That's the bottom line, is if you have a trust, put stuff in it, and make sure all of your beneficiaries are up to date and they make sense.
Yeah.
Like, and that goes back to your point. Like, if it doesn't make sense, like if I have a deceased sibling or a deceased relative, I don't want to put them as a beneficiary of my trust. If I have somebody who I know is going to do stupid things with the money, or they can't handle their own money, I'm not going to make them the
Mhm.
trustee of the trust.
Mhm.
But the beneficiaries have to make sense, and especially when we don't want to knock people off any benefits, right? So
Mhm.
you want to make sure that everybody's taken care of. Like, it's not just about, it's about the client to a certain extent, and then we get to a point where you're dead.
Mhm.
And remember, we're doing a plan. We're
Mhm.
planning 4 phases of life
Mhm.
and post phases. So when
Yeah.
you're dead, what happens? Essentially, when you're done in our office, and I'm going to say this because I just talked to my legal practice coach. She's an
Mhm.
attorney in Ohio.
Mhm.
Meet with her once a month for an hour. And she always says, our job, if we've done our job, then by the time the client gets their plan or they've left our office,
Mhm.
their estate is settled. They've settled their estate while they're alive. They know everything that's going
Yeah.
to happen when they
Yeah.
die. We've removed the unknown.
Good. Good.
We've
Good.
fixed all the problems before they can start.
Mhm.
So that's the main value of the plan. Like, if you
Mhm.
bring it back down to the core,
Mhm.
we've settled everything before the issues even start.
Mhm.
Before any of, I don't have my family picture up there, before any of those people have to go to court
Right.
because I failed to do something,
Yeah.
because that's what it is. Like, if,
Mhm.
and I've
You're
told
being
clients this,
proactive versus reactive. Yeah.
I've told people this
Mhm.
because and this, it's always the guy that says this in a married couple. The wife will be saying something, and I'll ask the guy a question, and he'll say, and I can speak freely on this.
Depends on what it is. Like-
The guy's reaction is always, and they always do that. They lean back in the chair and they go, "I don't give a shit. I'll be dead."
Oh, you mean the
Yeah,
cuss word?
right,
Well,
yeah.
yeah.
So
I'm
it's-
like, what are we talking
it's,
about?
I don't give a shit. I'll be dead.
Yeah.
That's their common theme, right? It's, I don't
Yeah.
give a shit. I'll be dead.
Mm-hmm. That
And-
sounds like my brother, like word for word, right?
Yeah, but,
Literally.
but now
We're all gonna die, you know. Yeah.
right?
Mm-hmm.
So it's always the guy that says,
Mhm.
I don't give a shit. I'll be dead.
Mm-hmm.
But it's like, all right, but this isn't about you. It's not, at that point, it's not about
Yeah.
that person. I always say, look, if your kids have to go through probate, that's your fault. You not doing this, like, you might not give a shit because you'll be dead.
Yeah.
But right now, in this very moment, I'm going to tell you what your kids are going to go through if things go left and you don't have a plan.
Yeah.
Because
Yeah.
if things go left and you do have a plan,
Mhm.
it's probably been thought out.
Yeah.
You know,
Yeah.
like,
Yep.
and here's the other thing. You can change these things. I told you, one person before you even signed 15 changes. These things are written in sand, not stone.
Mm-hmm.
They're supposed to change with your life.
Yeah.
It's a breathing plant.
Mm-hmm. And you can have multiple trusts.
You can.
Okay.
For different reasons too.
Okay.
Like, my
Okay.
dad has a revocable and irrevocable.
Okay.
A lot of people have that set up
Okay.
when it makes sense.
Okay.
So it can change. You're allowed to change these things. These are your intentions. They,
Mhm.
again, annual reviews,
Mm-hmm.
things change. So keep up with it.
Okay.
And I always say, if you don't keep up with it and your kids have to go through things, again,
Mhm.
it's your fault.
Mm-hmm.
It's your fault.
Mm-hmm.
It's
Now,
simple.
is when you talk about, so the cost, like you pay for it and it's one and done, it's only during those annual times where we have to like pay you again, or how does that pay structure work for you?
So with us,
Mhm.
we do everything, most things,
Mhm.
on a flat fee.
Mhm.
So I know the time, the effort, and the value that
Yeah.
just a will plan with beneficiary designations to make sure that you avoid probate, if that's your only goal, I know what the value of that plan is. So we priced it out accordingly. I know what the value of the revocable trust plan was.
Mm-hmm.
So we have a value behind that, and it's a flat fee. Same thing with this. We have starting flat fees for everything. And as we're going through the initial vision meeting, if we have a feeling that you're going to be in a trust plan,
Mm-hmm.
and I start asking you about assets, and I hear that you have 15 houses,
Mhm.
rental properties, this is true. I gave them the quote. We start at $3,950.
Mhm.
I'll give you that much.
Mm-hmm.
For a revocable,
I wasn't going to say the amount,
for
but
a revocable
okay.
trust plan, I'll give you that.
Yeah.
We charge $3,950.
Yeah.
And I said right off the bat, I was like, you guys need a revocable trust. Great, sure, let's do that. It's going to be $3,950. Okay, now let's go through your assets. They had 16 rental properties. You know what that means? With that $3,950, because it's a flat fee, I eat all the fees for you.
Mm.
So with that $3,950, I had to go record 16 deeds. Each deed that I record is $30.
Mm.
So I had to cover well over $300 worth of fees,
Mm-hmm.
close to double that, close to $600 worth of fees, because that was my fault.
Mm-hmm.
I didn't do my due diligence. So that's why we started saying we start at $3,950.
Lesson learned.
Because, and that's the thing too,
Yeah.
like extra deeds, we usually charge for that.
Yeah.
So
I mean, it's extra work.
one deed
Yeah.
comes standard. Sometimes I'll throw in an extra one just for fun. But when I start seeing them rack up, I'm not going
Yeah.
to charge you $450 per deed, but we're going to make it so, it makes
Mhm.
sense for everybody.
Mm-hmm.
Like I don't nickel and dime people. That's why we
Mhm.
do the flat fee.
Okay.
But for that particular trust, it's $3,950.
Okay.
So we start there.
So can you so let's say I did own, say, 15, 16 homes here in the Metro Detroit area, and it's underneath my company.
Uh-huh.
Then do I put the company into the trust, or
We
do I,
We do a transfer there's an LLC transfer of LLC into the trust.
but I don't have to do the individual properties
Nope.
because they're underneath the company?
Correct.
Okay.
Yeah.
All right. That's
Correct.
good.
I
All
mean,
right.
it's safest if you do that, but
Yeah.
if they're already in the name of the company,
Mm-hmm.
that LLC, like I said, is a bubble.
Mm-hmm.
And then when you, if it's S corp, it's also a bubble.
That's it.
But
Okay.
you toss that bubble into a
Mhm.
box,
Mm-hmm.
and you're double protected.
And I could say, okay, I want these three houses to go to this son, these three houses to go here. I can literally,
Correct.
even if it's underneath the business.
Correct.
Okay.
So like
Okay.
you can get as specific as you want with the trust.
Mm-hmm.
Again, and I have my dad's permission, so it's not like I'm giving client information. But with my dad, he's got a couple different accounts. Like he's got a 401k and an IRA, or I'm sorry, he's retired, so IRAs, and a couple life insurance accounts.
Mhm.
So with the, first of all, IRAs and 401ks, they can't be owned by a trust. They have to be owned by an individual. So with those, beneficiary designations every single time.
Okay.
So the beneficiary designation on his IRAs are the trust.
Okay.
But in the trust, it says from IRA account number XYZ 459, whatever it may be,
Mhm.
I want that to be split between my son's
person.
kids.
Okay.
For IRA, this one, I
Mhm.
want that to be split between my daughter's kids.
Gotcha.
So when I ask my dad for some extra money, I say, take it out of her account. I want my kids to get a little more.
That's funny.
Right here.
You're right.
Right.
Then he's going to take him off of his trust
Right.
when he hears that.
Right.
Well, I definitely appreciate you educating us. Any additional questions? This is the last. Yes.
What would be the purpose of having both of these exact trusts? Why
Both.
would I need both of those?
Okay, so the question was, why would I need both of those?
Mhm.
Control.
Mhm.
Okay, control. If I want to protect some of my assets, but keep control of a small portion that is open to creditors, so like the money I'm using for paying my bills, that's
Mhm.
not going to go in here.
Because you
Because
can't
I-
access it.
Not just because- Yeah.
Yeah.
It's
Yeah.
almost like owning a business. You know, how you're not supposed
Mhm.
to commingle funds or like
Mhm.
blend the funds when you own a business
Mhm.
between your personal and your
Mhm.
business
Hmm.
for accounting purposes and
Yeah.
things like that. Same thing.
Okay.
Your non-protected assets and your protected assets. You
Mhm.
don't use protected assets to pay for non-protected things because
Gotcha.
now you're using that money
It's
for yourself.
counterproductive. Yeah. Yeah.
Unless you're pulling
Yeah.
it from income. So there's
Mhm.
nuances. So I guess to get back to one of your original questions,
Mhm.
but yeah, so that would be the purpose, control.
Mhm.
So if you want to maintain control over this stuff and still avoid probate with it, because remember the only thing that we were missing with that one trust was asset protection. So if you want asset protection, avoid
Then
probate
do-
and control, you have to shift some of your assets into this trust.
Mhm.
So, and we helped the client through all that. We asked certain questions like, how much do you think you'll need for this, that? What if you get hurt and you need to be
Because
able
some
to
clients
run?
probably come in and say, I want this kind of trust. But then when you look at everything, you may say, no.
Most clients come in and say,
Okay.
I want this.
Okay.
And I just say, why?
They probably use chat like I was like, oh, this is what I need.
But
You
I
know,
do.
so.
I say, why?
yeah.
Because my neighbor has that. Well, okay. Your neighbor also
Yeah.
has 5 kids, 2 dogs, and like 18 houses.
Yeah.
You
Yeah.
have a condo and a cat and a car. You guys don't need the same thing. Your lives are not the same.
Yeah.
It is what it is. Really quick to get back to one question that
Mhm.
I didn't answer yet. On an annual basis, we offer, and a lot of other attorneys offer this too,
Mhm.
maintenance plans on your plan. So normally we have hourly fees when we meet with people to figure out what changes they need to make. If there are changes, I have a minimum drafting fee that
Mhm.
we do.
Gotcha.
So when somebody comes in and says, hey, I need a change made, if they're in our annual maintenance program, which isn't really that expensive when you're
Mhm.
looking at everything
Mhm.
that can be involved, like for a will plan and one revocable trust, we charge $550 for the year
Mhm.
to be in our annual maintenance plan. If you have one of these, because it takes a lot of consulting sometimes for people to get the hang of it, it's $1,250 a year.
Mhm.
But there's a lot more involved with this when we're
Mhm.
working with people, because there's a lot of issues going on that would point
Yeah.
us to that direction.
Some people pay that amount in
Right.
the internet cost. So
Yeah. So it's not that bad. But
Yeah.
what those people all get is at the very least one review meeting with me for the year.
Mhm.
At the very, very least. And I'm very generous with my time too.
Mhm.
So if somebody calls, and we like to charge everybody, but sometimes people get away with it. But $1,250 for the cost. They get one annual review, unlimited phone calls with boundaries. Like, don't call me at 12 o'clock in the morning. Like, it's not, we can wait.
Mhm.
So you get that additional education. So we do workshops like what does it mean to be a trustee or a fiduciary?
Oh,
So they have
okay.
special workshops
That's
for
good.
that. Once we get enough clients into that program that are
Mhm.
paying us for that, we
Mhm.
can see we can now have a set amount every year. So there's a budget involved.
Mhm.
And when that budget grows, then maybe we can start doing like client appreciation events and things
Yeah.
like that.
Yeah.
Like bring all our clients into a space like this
Mhm. Mhm.
and let them mix and mingle, because you never
Mhm.
know how, when people connect, maybe I introduce somebody who's got an ailment to a doctor that can fix that.
Yeah.
Maybe I've got somebody who wants to sell a business and I can introduce them to somebody who's buying a business just by having that client interaction there.
Mhm.
So it helps with deal flow for a lot of people.
Mhm.
Maybe somebody gets a job out of it because there's a business owner hiring and they met somebody at that event.
Yeah.
So
that's why I like doing these types of things. And I don't like I said, I'm like, at the time it's free. Okay. So, but the goal is to educate people in ways that we've never been educated. Right.
Mhm.
Because normally, nowadays you can go on YouTube, but you don't know that you're not able to. It's just like a doctor, right? You can't just look up one thing and be like, oh yeah, this is what I've got to do, blah, blah, blah. You could start taking something that can put you into hypertension mode. You could take something that's now giving you paralysis. So I think everything is customized. So that's why I think it's important for people to educate themselves, at least on the high level, right?
Mhm.
But then go to the SME, come to you and say, okay, help break this down. So, because just because we're having this conversation here doesn't mean like this is it. And I think at the beginning, he said there's 87 different,
There's a lot of different types of trust.
like
around
that's
87.
crazy. We talked about what, 2?
Yeah.
Overall, the big picture of 2. So, did you have another question? Because I'm reading your body language.
Do you recommend a married couple having a joint trust, or can you have separate trust?
So with that, I'm never going to give a general answer on that and a recommendation, because that's very specific. It's dependent on that couple,
Mhm.
their asset situation, their tax situation, their estate tax situation,
Mhm.
their control levels, how the couples interact. Is it a blended family? Is it a first marriage versus a second, third, or fourth marriage? Are there trust issues? Because you can read
Mhm.
that. If I'm in a client situation and it's a married couple, you can read tension. If I bring up their kids and I say, tell me about your kids. Oh, we have 4 of them. Tell me about them. There's this one, there's this one, there's this one, and there's this one.
It's like, oh.
Like you can read all this stuff, right? Like the
And
last
then
one,
this
it's like
one.
there's this one. What do you want to do with this one? We don't really need that person in our plan. Can we do that? Yeah, you can absolutely disinherit
Wow.
somebody. So it really depends on the individual. So what do I recommend? Like I said,
You can come and talk to him.
there's
And-
there's 2 rules of thumb that I
Mhm.
have. It used to be 1, but until recently it was 2. Or recently became 2. The first one, anybody over the age of 18 should have powers of attorney in place. So powers of attorney, 18, get them in place. That's my
Yeah.
first rule of thumb.
You hear that?
Second rule of thumb, they're dirt cheap too, like $40,000, $50,000. Don't even worry about it. I'm kidding.
I'm like, what? Like, I'm an intern.
And we have interest-free payment plans too. No credit checks involved.
Just have it under-
But no, they're really, really not. It doesn't make a $600
That's it?
piece sound that bad anymore, does it?
She
But
was like,
no,
what?
powers of attorney always at 18. The only time I will ever say anybody absolutely 100% needs a trust without telling me anything else other than they have minor children, that's it. That's my rule of thumb. If you have minor children, you should have a trust.
Mhm.
Because that's the biggest thing that leads to
Probate.
probate.
Yeah.
And if you have a minor child, you're going to go through probate anyways because
Mhm.
of guardianship.
Yeah.
If both biological parents pass,
Mm-hmm.
you're always going to have a guardianship situation because
Mhm.
of that. Now,
Is that something that can be when you do the will, like hypothetically, like whatever, like having a blended family, one passes, and if you know, are that connected and trusting that person with your child, can you just will that and then avoid probate?
no. So
Okay.
we never touched on this. So I'm going to take this as a question. Hey, does a will avoid probate?
Does a will avoid probate?
The question was, does a will avoid probate? And no, it does not. So the will's job is to put your intent. Remember I told you how the court has rules and the government has an estate plan for you
Mhm.
already. And when they administer it, they use their rules. A will is just your intentions put into their process. So it's
Yeah.
basically us saying, look, we know that we have to go through your process in these situations. So if we're stuck in this situation, we'll go through your process. We'll give you the process, but you're using our rules.
Mhm.
So it's like I'm giving them a recommendation, but then they're just making.
Not a recommendation. Not a recommendation. You're giving them your intentions.
Okay.
This isn't like a, you can do this if you want to type of recommendation. This is what you're going to do because this is what I want to have.
That's what
Yeah.
Yeah.
So it's a demand. It's not a recommendation. It's a demand.
Mm.
So this is what you're going to do because this is what I put in my will, and you've already said it's a valid will.
Got
So that's what the probate process is. So it's you saying, I want this person as my personal representative to manage everything. I want these people to be my beneficiary. I want these people to be guardian of my minor
Yeah.
children.
Yeah.
That's always going to have to go through probate, the kids.
Mhm.
Now, if the kids and assets have to go, those assets are on behalf of the kids. So the judge gets to monitor,
Mhm.
and we've got a conservatorship.
Mhm.
If the will goes through and the minor children go through for a guardianship, but everything's in a trust, whoever that trustee is that I've chosen
And can control.
can now manage everything
Yeah.
on behalf of the child.
Yeah.
And usually that trustee, that backup trustee, matches with who the guardians of my kids are going to be.
Gotcha.
Can you have two backup beneficiaries? Like I can be the grantor and I can be the trustee on the irrevocable trust. Can I have two backup beneficiaries?
You can have as many as you want.
Oh,
Yeah.
That's a good.
Beneficiaries, you can always have as many as you want. Backup trustees, you can have as many as you want.
Really?
Doesn't matter. Oh, you should have a backup trustee. Yeah, in a plan, you always have a backup. There's always backups.
Okay. Well, any additional questions? I want you to please give out your contact information. So do you have a website? Do you have a social media site? So whatever it is.
I'm a ghost, man. No, I'm kidding. I do. Can you go to like the very last slide of this presentation?
All right.
But yeah, everything is Chawla Legal, CHAWLALEGAL, all together as one word. It's my last name because we're all a little narcissistic when we're lawyers. But Dinesh at Chawla Legal is my email address. The website's chawlalegal.com, YouTube at Chawla Legal, Facebook /Chawla Legal.
So we'll put that here after. I'll go back and have to put it on there. So
I'll put it.
You're putting it on there now,
too.
or no? Oh, he's putting it on. He put it on there. Thank you.
Thank you.
Well, thank you so much. I know
Thank
we
you for
could
having
be
me.
probably here like another 2 hours,
I
but
could be here 15. I could do a stand-up routine too if you guys wanted me.
so I forgot. We're not gonna get it. That's a whole nother show.
That's a different show.
That's the side gig. I think everybody has a side gig, but
Yeah.
please do scan his QR code. If you know anybody, if you run into anybody, please do share it.
So I'm sorry. This QR code, because this is my normal presentation. This QR code it's not my contact information. This is just an evaluation for the presentation.
We'll evaluate him.
So if you want to evaluate my performance on this podcast, by all means, check that QR code.
Please do. And I'll still send out one because I definitely want to get feedback. But thank you again. I appreciate it. I have like all these ideas and thoughts and stuff like that. And any final closing remarks or thoughts or anything to those here or online?
Yes. Don't try to do things yourself. I'm not saying that you can't. Because you can. You can get these documents all together and you can put your intentions down. That's fine. Have somebody review it at the very, very least. Like one of the biggest hangups people have is the cost, but I see an upfront cost, but I also see what happens on the back end when you don't do these things. And I can tell you what those costs are, and then we can compare notes and see what's better or worse.
Right. Yep. Okay. All right. Last question. That's it. Okay. Any other questions? You'll talk to him afterwards. We got only a couple of minutes. But thank you, everybody. Again, this is a new segment that's called Legacy Talks. So maybe he'll be back and we'll get deeper into the estate planning, or I don't know. I want to get ideas of what everybody wants to talk about. So again, a lot of this comes because people come to me and say, do you know anybody who knows this, who does this? Or I come through and I'm thinking out something myself. So I do know individuals that their parents are getting older. And I know this is another conversation, as well as Medicaid and Medicare and all that, as well as I know insurance expires. So that was another conversation I was thinking about, because that's what we ran into with my grandmother, is they had insurance, but it lapsed. It expired, I should say. So I thought about that. So we'll definitely have more of these. I want you guys to please comment or DM us. You can use the 50 Shades email, which is 50shadesoflife@gmail.com. That's 50SHA8DES of life @gmail.com. If you want to be a guest or you want to come to one of these events or something, please do reach out to me. We are also everything like his is Dinesh is it you said Chala Legal.
Yep.
Everything for us is 50 Shades of Life. So I'm not really going to create like a legacy talks type thing. So if you're interested and you want to come on here and talk or have an event here as well, like Dinesh did, please do let me know. Other than that, thank you, everybody. I appreciate you guys coming and staying over. But I think
Staying
we all
over,
got
yeah.
really, educated here. We had good questions, but thank you so very much. Awesome.
Take food.
So if you